Alright, before we even get to the legal drama, a judge with a QR code virtual background and a public satisfaction survey. I love it, but notice what just happened. This is a public court proceeding being live streamed, accessible to anyone. That matters. Michigan courts have been pushing for transparency, and this judge is leaning into it. So if you're watching this thinking it's just a routine status conference spoiler, it's about to get a lot more interesting.
All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access on our civil docket, both in the courtroom and also online. Also, I've got a fake background behind me with a QR code that lets you know that we are in the middle of our biannual public satisfaction survey. So you can use that QR code to access that. There are also written forms in the hallway. And if somebody wants to participate through the QR code and can't manage to access that code from the device that they're on, which I can never manage to do myself, just reach out to the circuit court office and we'd be happy to get that form to you. So we have a status conference at the court scheduled in Lowry v. Michigan Unemployment Insurance Agency. It's a administrative appeal. It's file 26-9188AE. And Mr. Lowry is in the courtroom representing himself as the appellant. Good afternoon, sir. And go ahead and place your appearance on the record, Ms. Bryn.
Good afternoon, Your Honor. Assistant Attorney General Tara Bryn for the Unemployment Insurance Agency.
Okay, so I had entered an order back in March directing the parties how to proceed because I noticed on review that I had given Mr. Lowry a bit of bad advice or bad direction and told him that it was his job to get the record, which it would be in most appeals, but on review, that was the job of the unemployment insurance.
Hold on, did a judge just openly admit he gave bad advice to a self-represented litigant? Yes, and that's actually a big deal. In most administrative appeals, the appellant, the person challenging the decision, has to compile the record. But in Michigan unemployment appeals, the agency is required to submit the certified record. The judge caught his own error and issued a corrective order. That's the judicial process working as intended, but it also cost Mr. Lowry time. This case has been grinding since 2021, and even procedural hiccups matter when someone's livelihood is on the line.
Commission or agency. So I entered an order to that effect. We didn't see it filed, so we'd set this status conference for today. I will indicate that on today's date, we did in fact receive the certified record.
Great.
So that addresses the question that I had about that for the status conference. And so, Mr. Lowry, what that means for this appeal, I am going to direct the clerk to, on today's date, sign the notice to the parties that the record has been so filed. And that means that now we can trigger the briefing deadlines. So, Mr. Lowry, that notice being signed by the clerk on today's date, your brief on appeal, explaining to me why you believe that I should reverse the action of the agency, would be due not later than June 1st.
Quick play-by-play on what just happened. The judge set the briefing schedule and then miscalculated the date by 2 weeks. To his credit, Mr. Lowry caught it immediately. June 1st vs. June 15th doesn't sound like much, but when you're a pro se litigant, meaning you have no lawyer, no paralegal, no legal team, 2 weeks is everything. And here's the structure you need to understand. Brief, agency response, reply, judge's decision. This is the entire battlefield. Everything now comes down to what Mr. Lowry can put on paper.
June 1st is your deadline for your appeal. And then once you file your brief, the agency has 21 days to file a response brief. After they file their brief, you have 14 days to file any reply that you wish. And then at that point, the case comes to me to review the briefs and see if there's a need to schedule it for oral argument or not, and then to proceed on the merits of the appeal. Do you have any questions for me, Mr. Lowry, about that process for the appeal?
Well, I didn't quite expect a June 1st date for the brief. I was kind of waiting for the interrogatories, but doesn't look like anybody wants to answer the questions.
Well, that's a separate matter that I'll wanted to address since we're here anyway. Mr. Lowry, you keep filing various pleadings and discovery requests and other miscellaneous pleadings. And I want to tell you, everybody from the defendant to me are pretty much ignoring those. And here's why. This is an appeal. In an appeal, you filed a claim of appeal. In an appeal, here's what I get to do. Review this record and this record only.
This right here? This is the core tension of this entire case, and it trips up a lot of self-represented litigants. Here's the key distinction the judge is drawing. An appeal is not a new trial. There's no discovery, no depositions, no interrogatories, no new witnesses. The judge can only look at what's already in the certified record from the agency. The same evidence reviewed at the administrative hearing level. If you wanted to introduce new evidence, that had to happen way earlier in the process. Mr. Lowry is essentially trying to fight the war when the battle has already been decided at a different level. The brief is his one remaining weapon.
My appellate jurisdiction is limited to this is the record. Then you explain to me why they did something wrong. They explain to me why they didn't, and then I make a ruling. There's no discovery in an appeal. There's no new evidence in an appeal. You are not entitled to submit interrogatories to anybody. When you do, they can just object to them or not answer them. Heck, they could throw them in the trash as far as I'm concerned. It's an appeal. There's no discovery in an appeal. An appeal is limited to the briefs. You filed an appeal. So we are following the appeal rules. This is not a freewheeling forum for you to bring any complaint you want in the universe against these folks. This is an appeal from an agency action, and we're going to follow the rules for that appeal. Do you have any questions for me about that?
Well, what I've read, some of that I can understand, only in this case, my request is for fraud. And in the reading of the act, that's excluded from non-interrogatories. And I had mentioned that before, but as you said, they just ignored it.
Well, because I'm looking at, I don't know, what act are you referring to?
The Michigan Unemployment Compensation Act.
Okay. Well, that's an argument you may have on appeal that the agency prevented you from submitting evidence of fraud, right? But the appeal to me is not a case in front of the agency. It's an appeal to the circuit court from an agency action. My jurisdiction is fairly limited. It's to determine whether the agency made a correct decision or not.
The judge just dropped the word frivolous, and that's a legal alarm bell. In civil litigation, filing frivolous motions can expose a party to sanctions, meaning monetary penalties. The agency's attorney has been gracious in not pushing for that yet, but here's what's important. The judge actually gave Mr. Lowry a roadmap in this very exchange. He said the fraud argument could be raised in the brief. He also suggested Mr. Lowry could file a separate lawsuit entirely, or even challenge whether the certified record is incomplete. These are not dead ends, they're different doors. The question is whether Mr. Lowry can channel his frustration into a focused legal argument before June 15th.
This is not a lawsuit. This is an appeal. So there's no discovery in the circuit court on this appeal. And, you know, the defendant, frankly, has just been kind of not responding or objecting to your requests. They haven't asked for any sanctions or anything, but they could, because it's frankly, it's frivolous for you to file those things. You can represent yourself if you want, but you don't get to make up your own rules. We have to follow the appeal rules. So if you're representing yourself, you gotta follow those appeal rules. And here's the bottom line. All the other stuff you're filing doesn't matter. The appeal record has been filed. Now you have 28 days, so till June 1st, to file your brief. Then they file their brief. You can file a reply if you want. And then I decide the case with or without oral argument as I see fit.
28 days from today's date.
Yes, sir. Yes, sir.
And you're saying it's June 1st and it's May 17th?
Oh, you know what? I must have miscalculated that. You're right. You are right. May 18th. Oh yeah, I'm sorry. I just calculated 14. You're right. You're right. 28 days of June 15th. Yes. June 15th. My apologies, sir. Yes, sometimes I say the dates wrong.
I can understand them wanting to lean to the appeal, but this is just a stepping stone from the beginning, and everything moved forward is always an appeal. And this is going before the circuit court, not the appellate court. And I read where the the appellate court has limitations.
Well, I am an appellate court in this case because you filed a claim of appeal. I'm not the agency. In an agency action, then the circuit court jurisdiction is an appeal from that action.
Well, if you don't have complete files furnished by the court, by the agency, how can you make a decision?
That's what the certified record is. They submitted the certified record today's date, so you should get a copy of that.
And they only put one area in it. And this has been going on since 2021.
I don't know what to tell you, Mr. Lowry. I have to follow the rules. And whether you think I should ignore the rules or come up with new
No,
rules
I'm
that
not
you like,
asking you to ignore the rules.
I gotta follow the rules. And the rules are, that's my record. You all file your briefs, and then I decide the case. I am sitting in appellate jurisdiction in this case. I am an appellate court of the agency action. So that's how I have to proceed. If you want to file a lawsuit against the unemployment insurance agency or the schools, that's an entirely different action. And I can't give you any advice about whether you have a valid lawsuit that you could file against them in this court or another court or federal court. I have no idea. You know, you can take whatever remedies you think you have at law. What you have filed in this case is an appeal. And so I'm going to follow those rules. Any
So
other
I'm
questions?
stuck with what they control coming into this court, sir.
You are stuck with the record on appeal. I don't know. I don't understand the nature of your question. If you think that they have filed a record that is incomplete, you can file a motion in front of me saying that the record is somehow wrong or incomplete. But I'd encourage you to review the appeal court rules to see how to do that. A lot of the stuff you've been filing is if this is just some standalone lawsuit, which it is not. Okay. Any other questions for me, Mr. Lowry?
Well, this case started with civil rights violation, and somehow everybody has been able to dodge that issue up to date. And I can't see why I would come to a courthouse and be ignored for that reason. And it's gone all the way through. No one, yourself included, addressed the civil rights action. When I started this, we were threatened, the bus drivers were threatened that they could not draw unemployment and they would fight it. The following summer, the school allowed our female bus driver to draw unemployment. And that has never been addressed by this court, by the attorneys, or by the agency. They've all ignored it.
Mr. Lowry, all I can tell you is my jurisdiction is triggered when people file cases. You filed a case and it was captioned a claim of appeal, and you appealed from the agency decision. And you went through the appeal to circuit court and you say it's a fraudulent denial. Well, so I have my appellate jurisdiction. A lot of the stuff you're talking about, if you think you have a lawsuit against the schools for some civil rights violation, you pursue whatever remedies you think you have.
It's not against the school, it's against the system.
Well, whatever.
You know, just because I'm a male, we don't have a right in the courtroom or in the agencies.
You have the same right in my courtroom as anybody of any gender, Mr. Lowry, and I'm going to exercise my authority under the appeal rules, and I'm going to apply those rules to your case. So I've explained to you, my jurisdiction in this case is appellate jurisdiction based on what you have filed. So I'm not going to get into a long debate with you about that. That's true. If I did anything else, I would be breaking the law.
And there it is, Mr. Lowry's civil rights allegation that male bus drivers were denied unemployment while a female colleague was granted. It is the emotional and legal heart of this case. That's a potential equal protection or Title VII adjacent claim. But here's the hard truth. This court cannot address it, not because the judge doesn't care, but because the case is structurally an agency appeal, not a civil rights lawsuit. To pursue that angle, Mr. Lowry would need to file a separate action, potentially in federal court. The judge told him exactly that. So what happens now? Everything rides on that appeal brief due June 15th. Can Mr. Lowry, without a lawyer, write a brief compelling enough to make this judge reverse the agency? That's the question. Drop your prediction in the comments.
So you've got your appeal deadline and your briefing deadline, and I encourage you to follow that. Ms. Bryn, anything further on behalf of the appellee?
No, thank you, Your Honor.
All right, thank you. So as soon as we get all the briefs, I'll review them and likely schedule it for oral argument. Everybody have a good day.
Thanks, you too, Your Honor.
Thank you.
All right, thank you, sir. Off the record then for a little bit.